Let the record reflect we're outside the presence of the jury, but we are in open court, ready to start with Thursday morning. Counsel?
Yes, thank you, Your Honor. Your Honor, the state had brought this up to the court earlier. I can't remember if it was this week or last week, but the state is going to request that we adjourn for tomorrow on Friday and reconvene on Monday. The state expects to finish its case this morning. We have 2 witnesses left. The state expects that the substance of the trial will be finished today, and we may have time to work on jury instructions today. If we don't have time to finish the jury instructions, we could do them on Friday. But even if we finish the jury instructions today, instead of doing closings tomorrow, the state is asking to adjourn until Monday. The reason the state is asking that is Sergeant Smith's wife, son, and daughter are wanting to fly to Washington, D.C. for National Police Week. They have a vigil Friday night in honor of Sergeant Smith and other officers that have lost their life in 2021. And then there is a memorial reading of the names on Sunday. State's understanding is those 3 would be able to be back Sunday night to be here Monday morning for closing arguments. They would prefer to be here for closing arguments, and they want to be at the National Memorial as well. Obviously, they can't be at 2 places at one time. The state does not believe that 1-day continuance would cause any prejudice in this case. The jury's already been admonished about not watching this case or reading about this case in the press. The court doesn't have to indicate why we are not convening on Friday. The court can simply indicate previous commitment. We're not having court on Friday. We will resume Monday with closing arguments. So that's what the state is requesting.
Mr. Havaker?
Thank you, Your Honor. We're not unsympathetic to the request of the family, but our job and primary concern, and frankly close to only concern, is or 2 things essentially. One is to make sure that Mr. Lang has a fair trial and also his own safety. And as regards to the latter, if we do this continuance and not move ahead to Friday, we would be prepared to argue Friday morning. I do suspect we would quite easily be able to complete the jury instructions this afternoon. Then that would involve additional transport of Mr. Lang. The second is the general concern about an uneven delay. While I understand the state's position and the court has done the admonition, the more time that lasts, the more risk that there is that the admonition could fail when jurors are left idle and not in the courtroom and not deliberating. That is more so, Your Honor, given the reason for this. As I understand it, that this would be the end of the National Police Week. That memorial, and the fact that the event is going to happen on Friday and Sunday, as Mr. Hamlin talked about, will be in the news. And I'm guessing on most, if not all, media outlets, especially locally, including newspapers and television, which makes that risk of failure of the admonition that much more heightened. So again, we are not unsympathetic, but we would resist not plowing ahead and arguing on Friday. Again, assuming that we can get the jury instructions completed on this afternoon, and I have no doubt that we can.
I intimated to counsel the first time this was discussed, I believe it was at the pre-trial. I'm not sure what day it was, but it was before the trial started, that I would be willing to entertain a delay, and that it would need to be made. And I was anticipating it was coming on Wednesday or yesterday. I'm inclined to grant the delay, not necessarily just because of the family's request, but also, as I intimated before, and then if this trial was really going to be ending sometime around Thursday, Friday, that we would utilize that time to do instructions, to make copies for the instructions, and make sure that we're ready to go. As I've indicated to counsel, as the trial court in a trial, particularly a trial of this nature, I think percentage-wise, the number one concern on appeal is issues dealing with instructions. And so I don't want to rush those. I told counsel even before this issue was raised that we will be pumping the brakes when it comes time to deal with instructions. And so I'm inclined to utilize the remainder of today if that's what it boils down to. I'll take counsel's word for the fact that they may believe it's going to get done earlier today. But there's no guarantee of that. And so it will be my intent to utilize the remainder of whatever's left of today and potentially tomorrow to hash out the instructions, and we'll have the jury ready to go on Monday. So plan accordingly, counsel. Just for the record, I did send out in the evening the court's draft set of instructions just for clarification and confirmation. Can counsel indicate for the record you received it?
I received them, Your Honor, but I was not able to review them last night.
Yeah, that's fine. I just want to make sure you got them.
Yes.
I don't want to have anything that's considered ex parte where I sent it to one and it failed for the other side or anything of that nature. How about from the defense?
We received it, Judge.
Great. Okay. We all have technical issues, but we had something going on there back from the media, low battery or something. We don't need to go on the record. We'll just go off the record here for a second. But low bat.
I apologize. My laptop decided to crash.
Okay.
Dramatic crashing.
All right. So fair enough. We all have issues.
All rise for the jury.
Okay, be seated. Good morning. I always get a little chuckle out of my juries. They get a little possessive of their seats, and after a while, folks just kind of have like assigned seats when it just never fails. So, counsel, are we ready to begin with our witness today?
Yes, Your Honor.
All right, let's
State
call-
would call Michael Tate to the stand.
Come on up, have a seat, or have a seat, just come on in. Can you raise your right hand? And do you swear or affirm the testimony you're about to give will be the truth?
I do.
Have a seat, please.
Thank you.
Can you tell me your full name?
My full name is Michael Martin Tate.
Can you spell your last name for us?
T-A-T-E.
Thank you.
You're welcome.
Counsel?
Thank you. Mr. Tate, where do you work?
I work for the Iowa Department of Public Safety, Division of Criminal Investigation, Criminalistics Laboratory.
And what is your title there?
I am a criminalist.
What section of the laboratory, the DCI laboratory, do you work in?
I am assigned to the firearms and tool mark section of the laboratory.
And how long have you worked there?
I've worked for the laboratory for about 32 and a half years.
And how long have you worked in firearms and tool mark section?
Unofficially, I started working in there doing, on a part-time basis in the fall of 2007. Officially, I moved over in April of 2015.
Can you briefly go through your post-high school education?
Yes. I have 2 bachelor's degrees. One is in the Administration of Justice from the Pennsylvania State University. The other one is in Forensic and Toxicological Chemistry from the Westchester University, which is also in Pennsylvania. Soon after getting the second degree, I got the job here in Iowa and moved out here. Since that time, I have taken a number of courses and seminars and such put on by ATF, FBI, DEA, other laboratories, instrument manufacturers, and the like, even other laboratories on their techniques that they've developed. Most notably, I am a 2016 graduate of the National Firearms Examiner Academy that ATF puts on.
Mr. Tate, I want to talk to you about some things you examined in this case, okay?
Yes,
Did you examine a Mossberg Model 512 gauge pump action shotgun?
yes, sir, I did.
And when you examined it, explain to the jury what process, how did you examine it?
Well, once I obtain the evidence that I'm asked to examine from the laboratory's evidence room, I'll take it back to my section and check to make sure the box is in fact sealed, break the seal, make note of it whether or not it is sealed, break the seal, and then open it up and start taking notes about what I see in the box before I even remove it from the box. And then I go on and go through it, noting things like the make, the model, the safety, where's the safety positioned, where's the serial number, and all those things, are they intact? And does it appear at face value to actually be in a functional state when I've received it? Once all of that is done, I will test fire the gun to make sure that in fact will fire what it's the cartridge or shot shell that it's expected to. And I'll take it into our range, and a minimum number of shells we usually put it through, or cartridges, is 3.
So in this case, did you examine the 12 gauge shotgun?
I did.
What type of condition was it in?
It was kind of dirty. It had what I thought was a type of insulation. It reminded me of this denim insulation that we have actually as soundproofing in our range. It was all over it.
And so it's fairness to you, you didn't see pictures of how the shotgun was collected at the scene, did you?
I did not.
Did the shotgun, did it function the way it's supposed to?
Yes, it did.
And did you test fire it?
I did.
And did it work appropriately when you test fired it?
Yes, sir.
And did you fire 3 rounds?
At least 3, yes.
Okay. May I approach the witness, Your Honor?
You may.
Mr. Tate, I'm going to show you what's been marked as State's Exhibit 5. I'm not trying to get anybody with the box. Is this the shotgun you examined?
Your Honor, may I?
You may.
Thank you. Yes, it is.
And can you show the jury how this shotgun functions?
I can?
Okay. And may this witness stand if he needs to, Your Honor?
You may.
Thank you.
And did you bring any of what you, can you explain for the court, if you brought any rounds, what type of rounds they are?
Yes, what I did bring today was a number of, called, and easiest way to say it is they're dummy rounds. They are shot shells designed for proving the action of the firearm that I want to look at. We have these in all sorts of different cartridges as well, but this ones are actually 12 gauge. This happens to be one for a 2 3/4 inch shell, which was similar to what was used in this particular situation. There is no primer, which would normally be in the center of the base of the shot shell, and there is no powder in here. There is, however, shot to give it weight to allow it to function, because a light shell may not function the system as we would expect it to.
And by using these dummy rounds, is it safe to show how the gun works with these dummy rounds?
Yes.
Okay. With that understanding, Your Honor, may he show how the gun functions with the dummy rounds?
You may.
Where would you like me to do this, sir?
I'll defer to counsel.
Mr. Tate, it might be easier to give you more room if you come down to the middle here. You have to keep your voice up unless you prefer moving your chair back and standing there by the microphone.
I don't care which one you would prefer.
Okay, I would think you get more room down here if you want to come on down.
All right.
And I can get the box out of your way.
You're fine, thank you. All
The-
right.
The court reporter's behind you, so keep your voice up.
I will try this.
Let me know. All right. What I have here is one of the Mossberg Model 500A pump-action shotguns. You have a magazine tube beneath the barrel. This happens to be chambered to fire the 2 3/4 inch shotgun, 12 gauge shotgun shell. You can also fire, according to the barrel here, 3-inch shot shells. By pump action, what it does, it means is that, in fact, to load the chamber, which is up here on this portion of the barrel, the back portion, closest to the receiver, as you work the action. I am depressing the pump release or magazine release button, which happens to be on the underside here, just so I can show you the action. That is how it's opened when it's empty. When it's fired, the normal mechanism will actually release the system and allow the shooter to manually pump it without pressing this button.
And if you can show us with the dummy rounds how you would load it and how it works if a shot is fired?
You can simply put one, with the chamber open, bolt back the chamber open. You can just simply drop one in and then close the chamber, and it will be loaded. For demonstrations, I'm going to take it a little further, and I'm going to load 3 of my dummy rounds through the magazine tube and then show you how it works as it comes through.
How many rounds would fit in the magazine in this gun?
5. Okay, now I place 3 in the magazine tube. And when I'm ready, oh, and by the way, this is the safety lever. It is currently in the safe position. Okay. To take it off safe, I push it forward. But we're ready to load it, the chamber, what it is done is by pulling it backwards, it releases one of the shells from the magazine tube onto a carrier, which then, as I push it forward, brings it up and forward into the chamber. Now, at this point in time, I could just hit that little release button by the trigger and just fire the shell out. But if I were going to test to see whether or not the trigger works and everything still maneuvers, then you have to squeeze the trigger, take the safety off, squeeze the trigger, and that is the hammer falling and striking the back of the firing pin, which is in the bolt itself. And then at that point in time, it would have struck a primer if it had been in there. And then to load the next one, just simply pull it back, go forward again. And again, same sort of thing.
So, Mr. Tate, as you hold that there, what would happen is if you fired the gun, would the shot shell eject automatically?
Not automatically.
Okay.
The shooter actually has to pull this back.
So after, just so it's clear, so after the 12-gauge shotgun is fired, even with the slug, it doesn't make any difference, right?
That's correct.
You have to actually pull it back to eject one.
With this particular shotgun.
Okay.
A semi-auto shotgun, you do not.
But this one you do.
Yes,
So you got to pull it back to eject.
yes.
Then how do you, if you want to fire a second round, what do you have to do?
Well, by pulling it backwards, you're ejecting the old, and then the mechanism releases one from the magazine tube, if there happens to be one, and drops it onto the carrier, which then, as you take the forearm and push it forward, brings it up, and then the bolt push it into the chamber.
So there's two actions, one to pull it back to eject,
Correct.
and then pull it forward.
Yes,
Now it's ready to be fired.
yes,
So after those two actions, separate actions, you still have to pull the trigger.
that's correct.
Okay. Thank you. I'm going to actually, if you don't mind taking that back, I'm going to.
Okay.
Mr. Tate, I'm going to ask you if you would put the shotgun back in State's Exhibit number 5, but also I was going to ask you for safety purposes if you would put a trigger lock on and explain what the purpose of a trigger lock prevents happening.
The trigger lock, and this is specifically a trigger lock. There are also other locks. They're called cable locks, and they will slip through. This is the loading opening in this case, and in through the chamber, the bolt opening or the ejection port. You can use those as well. What it does, in either case, is the cable lock is better to prevent anybody from ever loading anything. This should prevent anybody from ever pulling the trigger.
So it's a safety mechanism.
Yes, it is. Just make sure safety's on. Sorry, muzzle's going to come your direction.
Mr. Tate, I want to ask you about some other items you examined. Did you examine the, would be your lab item number 28, 3 Winchester rifle shot shells that were removed from the defendant's sweatpants?
Yes,
And also 1 rifle shot shell that was unfired that was removed from the kitchen? It would have been your placard, lab item number 26.
yes.
And were you able to tell with those 4 unfired shot shells, would they have been able to fit into the Mossberg 12-gauge shotgun we just looked at?
Yes,
They would work in that gun?
yes, they would.
May I approach, Your Honor?
You may.
I want to show you State's Exhibit number 6. These are 4 fired 12-gauge shot shells that Tara Scott collected at the kitchen of the defendant's home. Did you look at these items?
Yes, I did.
And when you looked at these items, what were you looking for?
When I look at ammunition and ammunition components, I'm looking to see, well, could they have been fired in the firearm that was presented to me for examination? Were they fired? Do they have anything in particular about them, such as markings, to tell me who made them and what they could have had in them at the time?
And how do you go about determining in this case if those 4 shot shells, 12-gauge shot shells, were fired from the Mossberg 12-gauge shotgun?
Well, when we make our comparisons, the test fires come into use. The test fires that I took when I took the shotgun into the range and fired it, I will look at the tool marks that are made from the face of the bolt of the shotgun and any other portion of it, such as the ejector or the extractors that are on it, and look for those marks on the shot shells, as well as the firing pin impression. Those tool marks are all going to be unique to a gun because with use and time, it changes. It changes from gun to gun as they're made in the factory. So what I would have done is taking each of these, I would have looked at my test fires under what we call a comparative microscope. And what that is 2 single-stage microscopes that are connected together with what was called an optical bridge. And that allows us to look at both stages at the same time and make our comparisons.
And did you do that in this case?
I did.
And what was the results of your comparison?
I found, or I gave a finding of inconclusive.
And why was that?
Well, what I found, inconclusive, as much as it is a valid response by a firearms examiner, it's not one that we hope for. But in this case, what I had found was the breech face itself, which should have had machining marks on it from being made in the factory. It was coated with a layer of grime, and there was nothing for it to no way for the shot shell, which would have, when fired, it would have slammed back against that breech face, and if that breech face had been clean, that harder surface would have transferred its imperfections to the base of this shot shell, or any of these shot shells, and the test fires as well. And those are what I've been looking for to make the comparisons. But because, as I mentioned, that there was a layer of grime on the breech face, there wasn't anything consistent to make that comparison with, and therefore I had to call it inconclusive.
But there were similar characteristics on the shot shells compared to the test fired.
Yes, there were.
Okay. So State's Exhibit 6, the 4 shot shells that were found, fired ones that were found in the kitchen, you can't say just based on that test whether they were fired from this gun or not.
That's correct.
It might have been, but for this test itself, you couldn't say that.
That's correct.
But you did additional testing?
I did.
What additional testing did you do?
Well, when I found that I had run into that issue, the next step for me is to see, well, were these actually cycled through the firearm at some point in time? And my demonstration earlier showed you cycling, putting them into the magazine tube and then working them through the system. In doing so, the magazine has a catch to keep the shot shells within it before it's needed or called for to be chambered. So that could make a mark. In addition, this particular shotgun has 2 extractor points, and those are little clips, if you will, on the bolt that go around and grab the rim of the shot shell to pull it from the chamber after it's been fired, or even if it's not been fired, those are there to pull it from the chamber. The other item I've mentioned is called an ejector, and that's a device that's meant to, once it gets, the bolt comes back to a certain point and it still has hold of the shot shell, whether it's been fired or not, it simply kicks it out the ejection port.
So
Each of those will make a mark, or should make a mark.
So did you look at the test-fired shot shells that you did at the range with this gun, and did you compare those to the 4 shot shells, States Exhibit 6, to see if the 4 shot shells in States Exhibit 6 had been cycled through this gun?
Actually, I used live shells from our laboratory's collection and cycled those through on their own without firing them,
Okay.
and made my comparisons from there.
And did you take pictures when you made the comparison?
Yes, I did.
May I approach, Your Honor?
You may.
Thank you.
Mr. Tate, I've handed you 4 photographs. I believe it's States Exhibit 78 through 81.
Yes.
Are these just some of the photographs you would have taken to show your comparison to see if these shot shells had been cycled through this gun?
Yes, sir.
Do they appear to be fair and accurate?
Yes, they do.
The state would offer into evidence States Exhibits 78 through 81.
78 through 81 will be admitted.
Permission to publish?
You may.
Mr. Tate, there's a laser pointer that works some of the time on the TV.
Okay.
If you can describe for the jury States Exhibit 78, there appears to be a line down the middle of what we're looking at.
Yes, oh, it's just a hold on. Oh, it's not working well. All right. I'm just going to go with the description.
Okay.
What you see is a black line in the middle of the screen. We call that the line of demarcation. That to the left will be what was on the left-hand stage of my comparison microscope and what's on the right-hand stage. We commonly will put the known or the test-fired cartridge on the left-hand stage and the unknown on the right. And what you're seeing here are marks made on the rim of shot shell mark number 22. And this mark I was seeing consistently between the cycled and the fired, which the cycled would be on the left-hand side, or that could, a test fire, that would be actually one of the test-fired rounds.
This is one of the shot shells that's in States Exhibit 6 that you're looking at then?
The one on the
Right.
image you see on the right-hand side. And what I'm looking at on the right-hand side near the line of demarcation is not as crystal clear, but what you're seeing on the left, I saw on the right, and they are the stria, the scratches that are made by the individual tool. In this case, I believe it to be one of the extractors inside the shotgun that would have pulled it free. It would have had to go around and grab onto the rim, but in doing so, it went around that rim, and the edge of it scratched it in this pattern.
So, Mr. Tate, if I understand what you're saying then is, the test fires on the left, one of the shot shells that's in State's Exhibit 6 is on the right, and you're comparing to see if these lines match up.
That's correct.
And what was your conclusion?
That they in fact did, and that was one of the cycling marks that I noted.
So for the, one of the shot shells that we're talking about, number 22, lab item number 22, was that one cycled through this 12-gauge shotgun?
Yes.
Okay. I'm going to go to the next photograph then.
State's Exhibit number 79.
Can you walk us through this one again?
Okay, this is another mark that was made on, that I found on both shot shells, both the test fire and the unknown. Where I believe these marks were made were in fact by the, either the ejector or the catch that's in the magazine tube. And that, because as the shell is forced out of the magazine tube by the action of the pumping action, pulling that forearm backwards, it's got to push out and away past that clip, because that clip has tension to it. So it is going to scratch it. And these are the marks that I found on the actual base portion of the shot shell, rather than the rim, which is the edge.
So for this exhibit, what you have marked on the right-hand side is lab item 23. That's one of the shot shells in State's Exhibit 6.
That's correct.
What was your conclusion on this one,
That it was cycled through this firearm, the shotgun.
the 12-gauge Mossberg shotgun?
Yes, sir.
And the next one is
State's Exhibit number 80.
and again, if you would walk us through what you did with this one.
This is the same sort of thing as with State's Exhibit 22. This is Exhibit 24. This is the rim mark that I was found on, obviously the test fire on the left, the unknown on the right,
And what was your conclusion when you made the comparison?
that this one, this shell, number 24, was cycled through the Mossberg.
And finally, the fourth shot shell that's in State's Exhibit 6.
Should be State's Exhibit 81.
Yes.
Again, tell us how you did the comparison in this one.
This is the same sort of comparison. This was actually on the face of the cartridge, or the shot shell itself. And by face, I'm talking about what we call the head stamp area, or the very base of it. And again, the scratch marks are similar to what I saw on it. And there was a photograph from item 23.
So, Mr. Tate, State's Exhibit 6, what is your opinion for those 4 shot shells, whether or not they had been cycled through this 12-gauge Mossberg shotgun?
I believe they did, all 4 had been cycled through that Mossberg.
Did you also get to look at, may I approach again, Your Honor?
You may.
I'm going to show you State's Exhibit number 8, and these are some waddings that were collected at the scene. I believe 4 were identified in the garage, 1 was identified in the driveway, and 1 was identified by the north addition. Did you look at these waddings?
Yes, sir, I did.
When we say waddings, what does that mean?
Waddings are individual components within a shot shell that are placed there by the manufacturer to fill the gap that's within it. It depends on the manufacturer and what they choose to do when they build a shot shell, whether they're going to use plastic, cardboard, some sort of wax paper, or anything of that nature. The wadding will follow the projectile out the barrel as it's fired, and is often found at scenes.
And prior to coming to court today, did you have the ability to take a shot shell apart to show us the components of a shot shell?
I did.
And do you have that with you?
I do.
With the court's permission, may he use this as a demonstrative evidence, Your Honor? May.
Thank you.
Mr. Tate, can you explain what you did to the shot shell and the components of a 12-gauge shot shell?
Okay.
And this is a 12-gauge slug, I assume?
Yes. Yes, it is. What I have here is what was turned into me to examine were, amongst other things, Winchester rifled slug shot shells. They had two different markings on them. I went into our collection, if you will, and disassembled one of each different kind of marking to bring along today. This is the whole shot shell as it is, and this is live, so I'll keep it up here. I can certainly leave the remainder with the court if you'd like. But that is what a live 2 3/4 inch Winchester rifle slug shot shell looks like. Inside of it, what I did was, we have a special cutter. It's a matter of a box and a razor blade, and you stick it inside of a hole and give it a twist, and it actually cuts it off. This is the base. This is the primer, the base, and I have a bit of wadding in here because when I'm done, anytime I do this, I will fill this with oil to get it to destroy the explosive compound that's in the primer, because the oil will ruin it. This little vial has the powder that was recovered from this particular shot shell. And working backwards from the opening, this is the projectile. It is reportedly a 1 ounce rifled slug. Below it was and I numbered these 1 through 4 because there were 4. In fact, in this, both of them there were 4 components. This one was right below the projectile itself. And then it appears that Winchester decided to make up the gap and added 2 more paper waddings. And I numbered them 2 and 3 as they came out, because they would have sat like so far. And the last wadding is kind of a waxy, thick paper that is called an overshot wad. And this is number 4. And it just sat like so inside all of this.
So inside the 12-gauge slug shot shell,
Yes.
how many total waddings are there?
4.
In the one that you just showed us, are they paper or plastic waddings?
These are all a paper, essentially.
Do they have some that have a plastic wadding?
They do, and there was, the differences, I'll show you here in a moment, is that there were 2 different designations on the shot shell itself. One of them had the shot shell length below what says Super X, and the other one had it running along the side. The one I just showed you had it running along the side. This one that has it below it, I disassembled one of those as well, and its wadding was somewhat different. Again, the same kind of projectile and powder. Very similar undershot wad, if you will. But then the two spacers, if you will, to make up the gap, are significantly different. They're thicker and they're coated on both sides, as compared to, this is the one I just showed everyone, and this is one of the two from the one I'm demonstrating now. However, the difference between these two is that the over powder wad is plastic.
And again, the total number of waddings for that one equals how many?
4.
So the main difference is the over powder wad is plastic in that shell.
Yes, I would say so.
Okay. Thank you. If you don't mind putting them back in there.
No.
So then in front of you, what was collected, the 4 wads from the garage, the one from the north addition and one from the driveway, States Exhibit 8, those 6 waddings. What did you do with those? What did you do for comparison purposes?
Well, I would have taken them from the box and then, having disassembled one of each of the shot shells, I would have looked at them and compared them to try and get an idea of which kind of shot shell it was fired from, or which marking was appropriate to which shot shell.
And were you able to make any determination?
Yes, I believe I was.
And what were you able to determine?
If I recall correctly, they were the one with the paper wadding, paper over powder wad.
Did you look at some metal fragments as well?
I did.
I want to show you States Exhibit number 8A. These were collected by Tara Scott in the garage, 2 metal pieces of fragment.
Okay.
Did you look at those?
Yes.
And were you able to make any determination about those 2 pieces of metal? Let me ask it this way, it might have been
Okay.
a bad question. Were these 2 pieces of metal in States Exhibit 8A consistent with a part of a slug?
Would you mind if I open them up? It's been a little while.
No, no. Please feel free.
Thank you. Yes, they are. I do remember this now.
And can a slug, when it hits cement, can it fragment?
Yes.
Then also States Exhibit number 10, this was a piece of metal that was collected from a windshield of a Bearcat. You want to look
Oh.
at that?
Yeah.
Are you able to tell us if that's consistent with a slug as well?
I did look at it. My initials are on it.
Okay.
Oh, yes. It has the glass from the windshield. But yes,
That is consistent with the slug.
yes, it is.
Then finally, there was well, actually, two things. I'll get the other one. Did you also examine Sergeant Smith's rifle?
Yes, I did.
And did you compare it to two shell casings that were found in the garage?
I did.
Were you able to tell if those, well, one shell casing was in the garage and one was in the landing. Were you
Okay.
able to tell if those two shell casings were fired from Sergeant Smith's gun?
I was, and I did.
I'm going to show you next, State's Exhibit 7. It hasn't been offered into evidence yet. I'm going to show you State's Exhibit 7.
Oh, yes.
These were items that were collected from Autopsy. Did you have a chance to look at them?
I did.
And the items in the box, there's waddings and metal fragments. Did you look at the waddings?
Yes.
Are they consistent coming from the 12-gauge shot shell?
Yes.
The metal fragments, are they consistent with being fired from a slug?
They're consistent with being from a once part of a slug.
No other questions, thank you.
Ross?
None, Your Honor.
All right, you can step down.
Your Honor, would you like me to leave these shot shells that I disassembled?
These are the demonstrative pieces?
It is.
No. We'll clean them up, and you can either take them with you or counsel can have them, but the court's not going to take them in or receive them as they're not been admitted.
Okay. I wanted to ask before I left.
Understood. Ladies and gentlemen, just for a minute, I'm going to have you step out. This is going to be a very brief recess. So just stay in your jury room for a second. Okay, be seated. State, please call your next witness.
Thank you, Your Honor. State would call Dr. Dennis Klein to the stand.
Do you swear or affirm the testimony you're about to give will be the truth?
Yes, I do.
Have a seat, please. Can you state your full name?
Yes, my name is Dennis Klein, Klein.
Thank you. Counsel?
Thank you. Dr. Klein, where do you work?
I work at the Iowa Office of the State Medical Examiner.
What is your title there?
State Medical Examiner.
And how long have you been Iowa State Medical Examiner?
Since 2018. Excuse me, 2016.
And prior to being the State Medical Examiner, what was your position at the office?
I was Deputy State Medical Examiner from 2000 to 2016.
What are some of your duties as the State Medical Examiner?
So one of my primary duties is to administer the office, so I provide a supervisory role and administrative role for the office. In addition, I practice forensic pathology and perform forensic autopsies, and then I provide consultation to county medical examiners throughout Iowa.
Are you licensed to practice medicine in any states?
Yes,
In which states?
Iowa.
Can you briefly go through your post-high school education?
Yes, after high school, I grew up in Maine. I went to Bowdoin College, which is a four-year liberal arts college in Maine. I studied chemistry and got a Bachelor of Arts degree in chemistry. Then I went to the University of Vermont College of Medicine, where I received the MD degree. I then went to Boston, where I did 1 year of internal medicine internship, and then continued on at that same hospital doing anatomical and clinical pathology. And then after completing that program, I went to the University of New Mexico, where I did fellowship training in forensic pathology. So I took boards in anatomical pathology, clinical pathology, and forensic pathology.
Are you board certified?
Yes.
What does it mean to be board certified?
So board certified means that you have an MD or DO degree, you've successfully completed an accredited program in residency and or fellowship, and then you take and pass a comprehensive examination.
And you mentioned you're a forensic pathologist. What does that mean?
So if we break it down into forensic, which is we're dealing with the courts and the law, and pathology is the study of disease. It's a subspecialty of medicine that focuses on that area of intersection between medicine and the law.
May I approach, Your Honor?
You may.
Dr. Klein, I've handed you what's been marked as State's Exhibit Number 12. Do you recognize this?
Yes, I do.
And what is this?
It's my curriculum vitae or my resume.
The State would offer into evidence State's Exhibit Number 12.
No objection, Your Honor.
Exhibit 12 is admitted.
Dr. Klein, what is an autopsy?
An autopsy it's an examination, and it's an examination on a person who has died with the primary purpose of determining a cause and manner of death, as well as examining for diseases and injuries, and it's also the opportunity to collect various specimens for other medical type tests.
Is there a standard procedure or protocol you follow in an autopsy?
There's a general process for all autopsies, and then depending on the circumstances of the case, there may be certain specific things that are done for that case that wouldn't be done on other cases.
Can you explain to the jury in general what the standard procedure or protocol is for an autopsy?
Yes, much like when you go to the doctor and have a physical examination, as a pathologist, we do a head-to-toe examination of the body, looking for various features. We look for injuries. We look for various diseases. We'll disrobe the body. We'll look, again, for any types of injuries. We'll document those, both by taking notes that then get dictated into a report, as well as taking pictures. Sometimes we'll take an X-ray to look to see if there's any retained objects like knife tips or bullets. And then we make incisions into the body to actually observe internal organs to see if there's any diseases or injuries and correlate that with what we saw on the outside of the body, and then also correlate it with the circumstances around the death. We use that opportunity to collect specimens, everything from bullets to blood specimens that then can be tested later in laboratory by specialists in those areas of science. And then we put that all together with history to write a report, and that's the autopsy report. And then we also use then that to certify the death, which means to determine a cause and manner of death, which is put onto a death certificate.
At some point during the autopsy, do you wash or clean the body?
Yes.
And why do you do that?
Well, oftentimes when there is injury, there's going to be blood, and the blood is going to obscure key features on the skin that help us determine what caused that injury.
And approximately in your career, how many autopsies have you conducted?
I've done over 4,800 autopsies in my career.
I want to turn your attention to this case. Did you perform an autopsy on Sergeant Jim Smith?
I did, yes.
And did you follow the standard protocol?
Yes.
Can you explain on the external examination what you observed?
Before we disrobed the body, we did notice that there was a tear to the clothing. I was most focused my attention on the upper left chest. Mr. Smith was wearing a body armor vest. I noticed there was a tear on the strap near the upper left shoulder. I also noticed some tears of the clothing. Some of them may have been from medical personnel, and I also noticed some tears in the left pant leg. Then when we removed the clothing, I did notice that there were major injuries that were consistent with firearm injuries. After washing the body and taking an X-ray, I was able to determine that they were shotgun wound injuries that occurred with entrances on the upper left shoulder, chest area, and on the back of the left leg.
Do you determine person's height and weight at autopsy?
Yes, we do.
And what was Sergeant Smith's height
His 5'9"
and his weight?
was 154 pounds.
Do you have the age as well?
I was told he was 51 years old, and he was consistent with 51.
You mentioned you did an autopsy report in this case.
I did, yes.
Dr. Klein, I've handed you what has been marked as State's Exhibit Number 11. Do you recognize this?
I do, yes.
Can you tell us what this is?
This is the autopsy report. I'll just note for the record, it appears that page 8 is missing.
I'm glad you caught that. I may have a... May I approach your honor?
You may.
I'll staple this later, but I'm including a page 8.
Yes.
Thank you for catching that. The state would offer into evidence State's Exhibit Number 11.
11's admitted.
Dr. Klein, prior to coming into court today, did the state ask you to select some photographs that would be helpful for you explaining your testimony today?
Yes.
And did you pick out these photographs yourself?
I did, yes.
May I approach?
You may.
Dr. Klein, I've handed you State's Exhibit 82 through 94. Are these the photographs you would have selected? They may not be in the same sequential order.
Yes, these all appear to be the accumulation of photos that I had picked.
Thank you. Are they a fair and accurate depiction of how Sergeant Smith would have looked when he arrived and during the autopsy?
Yes.
State would offer into evidence State's Exhibits 82 through 94.
No objection, Your Honor.
82 through 94 admitted.
Can we approach, Your Honor? Can
Court?
attorneys approach?
Yes. Heed the admonition during the break. All right, be seated. Proceed, counsel.
Thank you. Dr. Klein, let's start with evidence of injury. Did you see any evidence of injury to Sergeant Smith's chest area?
Yes.
Describe for the jurors what you saw.
What I saw in the upper left chest near the left shoulder was a large defect with surrounding abrasion that was consistent with an entrance wound of a shotgun wound injury.
I guess we should have backed up. You said you took some pictures also of how Sergeant Smith arrived.
Yes.
I want to first start with State's Exhibit photograph number 82. And Dr. Klein, can you tell us why you selected this photograph?
So this demonstrates that the body bag, as we received it, was received in its intact form. So that blue tag with the number on it, that holds the zippers closed. So we know that from the scene to when we did the autopsy, no one had access to the body bag, to the inside of the body bag. And we also see that James Smith labeling that this is the correct body.
The next photograph, I want to go with State's Exhibit 83.
So this is a photograph of the body bag zipper being opened, and before we've done anything, we've done any cleaning, this is what we received. And so you can see that there's blood and there's defect up on the upper left chest, and hence the reason to remove clothing and to clean the body to really evaluate the injuries.
Next photograph, State's Exhibit 84.
So this is a picture of the inside of the body armor vest. You can see on the left, on the left strap. So we're looking at the inside of the body armor, and you can see compared to the strap on the right, the one on the left has a darkening and tear. And this was a result of the shotgun slug entering the body just underneath the body armor vest.
The next photograph will be State's Exhibit 85.
And these photographs are a little bit difficult just because of the dark nature of the clothing and the dark nature of the blood. But we can see this is the pant leg of that was removed. And you can see the darker staining on, this is the back, the left pant leg. And I'm not sure the jury will really be able to appreciate that, but there was about a 3/4 inch defect in the back of that pant leg, which corresponds with an eventual entrance wound that we saw on the back of the left leg.
So you mentioned, the next photo, State's Exhibit 86. Tell us what this photograph shows.
So this gives a total body view of the injuries that we can see looking at the front of Mr. Smith's body. The most important and lethal injuries on the upper left chest shoulder area. There's a gaping defect in that area, and then surrounding that is abrasion. So when you saw that vest strap up against that area, as the slug came, it just skirted underneath that vest, and it also caused damage to other areas around that entrance wound because the skin is lifted and slapped up against that strap, causing that large amount of abrasion on the upper chest. And then we also see, we'll have other photos that'll depict them as well, but those are exit defects on the left thigh. That's from a slug that entered the back of the left thigh and fragmented and caused multiple tears.
I'm going to jump to next State's Exhibit 88. Could you describe what this photograph is?
Yes, so This is focusing in on the upper left chest, front of the left shoulder area. You can see that large red area is a combination of the abrasion or scraping of the skin as the slug started to enter the body, and then towards the left side of that large red area is an open defect, and that's where the slug actually entered into the body and continued to travel through the rest of the chest.
Can you tell the jury where the slug would have traveled through Sergeant Smith's chest?
Yeah, so it entered just underneath the left collarbone, we call it the clavicle, and then it continued to travel from his left all the way to his right in a slight front to back trajectory. In that area of the body, there are major structures, including blood vessels that go right underneath the clavicle, the ribs, the left lung, the arch of the aorta, so there's the heart and then the large major blood vessel that is about the diameter of a quarter, comes off the top of the heart, that tore that major artery, and then it continued to damage the right lung, and then eventually we found damage and various fragments of the slug as far back as the muscles into the right shoulder blade.
Would this wound have been considered fatal?
Yes.
And did you find any indications of a part of a slug or a shot shell?
Yes.
What did you find?
I found they were gray metal, probably lead fragments. Some of them had almost a comma-type shape, consistent with my experience in retrieving slugs from other cases. So when the slug, which is a large chunk of projectile that's shot through a shotgun, when it enters and hits the body, it tends to fragment in these pieces. Along with that, there's what's called wadding, which is almost like a cardboard type of material that sits behind the slug, and that also was found along with those other fragments. And then there was also a piece of black fragment consistent with the black shirt that Mr. Smith was wearing also got pushed into the wound.
So were all the wadding, the pieces of slug, and the piece of his uniform or shirt, were they all inside his body?
Yes.
I want to show you State's Exhibit 94.
Can you tell us what this photograph shows?
Yes, so this shows the complete aggregate of the projectile fragments that are recovered from various parts of the chest, everything from the left chest, middle of the chest, and even back towards the shoulder blade. And the components, you can see the grayish metal fragments are the main parts of the slug. The tannish pieces, those are like that cardboard wadding material. And then the little black piece of fabric on the top, that's probably from the uniform shirt.
I want to show you State's Exhibit number 7. It's been taken out of the package, but the box is still here. Can you tell us if you recognize what's in the box?
Yes.
And is that what we see in State's Exhibit 94?
Yes, it is.
And that was collected during autopsy?
Yes.
The state would offer into evidence State's Exhibit number 7?
No objection, Your Honor.
7's admitted.
For the record, I'm going to take them out of the box, which has markings on it, and put it in the baggie, which is marked as State's Exhibit 7. Dr. Klein, the
Were you able to make any determination about the trajectory of the slug that entered Sergeant Smith's left clavicle?
Yes, it was predominantly a left to right trajectory, slightly front to back, and slightly downward.
Did you also look at Sergeant Smith's extremities, his arms or legs for injuries?
Yes,
Did you see any to his legs?
yes,
Did you see anything consistent with a bullet wound?
yes.
Can you explain to the jurors what you observed?
So on the back of the left thigh, so that's between the hip and the knee, there was a round defect that was consistent with an entrance of a shotgun slug. And next to that, so towards the middle portion of the thigh, was a tear consistent with an exit wound.
I'm going to put up State's Exhibit 93. And Dr. Klein, can you describe what this photograph shows?
Yeah, so this is the back of the left thigh. The small round dot on the lower left portion of the photograph, that's the entrance site of the slug. The large gaping defect where you can see muscle and fat, that's part of the exit wound after the slug had entered into the left thigh.
So in Sergeant Smith's left eye, the back of it, that would be an entrance wound
Yes,
to the back of his thigh.
yes.
I'm going to put up State's Exhibit 89. Can you tell us what this shows?
So this is, shows the middle towards the center of the body and the front of the left thigh, and you can see there are two gaping wounds. The wound to the left, you can see that there's, can I use a laser pointer?
You can try, but people
Okay.
have trouble with the TV absorbing it.
Right there. So that's what's called a marginal abrasion. So marginal means that it's beside something, and abrasion means it's a scrape. So when you have an abrasion next to a exit wound, it suggests that there could have been what's called shoring, so some sort of support of that portion as the fragments of projectile exit the body. And really what's happening is as that force of the projectile is coming through the body and that skin gets slapped up against something, and that could be a belt, a piece of clothing, another piece of body part, a floor, anything that allows that skin to slap up against it can cause that type of abrasion.
So in this photograph, this is the front of Sergeant Smith's left thigh.
Yes.
So if he would have been laying on the ground with his thigh on the cement in a garage and get shot in the back of the thigh, would that be consistent with that short wound?
I think either really tight clothing or maybe his other leg, so his right leg could have been resting on that area.
I'm going to show you State's Exhibit number 90.
What is this photograph?
So this is the right thigh, and this would be the middle, so towards the center of the body. So if you look at the right and left thighs, and they're like this would be in that central portion right here. So this is a contusion or a bruise, and it correlates in its location with that exit site and where that short abrasion occurred on the middle of the left thigh. So it's possible, and this is suggestive and supportive, that this right thigh may have been resting on the central portion of that left thigh at the time that that bullet is exiting the left thigh.
Now, would this wound have been a fatal wound? I mean, not with this one particular, but the one to his Sergeant Smith's left leg?
Yes, it could have been. As the projectile entered, it damaged a lot of muscle, but also damaged the major blood vessel that runs along the left thigh bone.
I'll just put next photograph, State's Exhibit 87. Can you tell us what this photograph shows?
So this is the left temple area. This shows an abrasion and a small little tear called laceration on that little triangular piece on the left external ear.
Do you know what would be consistent with causing this type of wound?
It's nonspecific because it's an abrasion. I think the possibilities are include him falling on an object. There's also a possibility this would be in the right location. In addition to the slug and the other wadding pieces, sometimes there are other pieces of wadding that if the weapon is close enough, there can be not necessarily in that exact same trajectory as the projectile itself, but I've had other cases where these other pieces of wadding or plastic cup components can hit the body, and they can leave non-specific type injuries like this.
Next photograph, State's Exhibit 92. What does this photograph show?
And so this shows, again, non-specific blunt force injuries, abrasions, so they're little scrapes. So this could have occurred when he falls. It could have occurred any time immediately before the actual shooting. But they're scrapes that occurred on the right side of the face and forehead.
The next photograph, State's Exhibit number 91.
And this is the back of the right forearm near the elbow. And then again, this is an abrasion, so like a scraped knee, probably from during the fall after he's been shot.
I think that'll conclude our photographs. I'll take that down. In this case, Dr. Klein, were x-rays done as well?
Yes.
And did they show anything?
Yes, they showed the X-rays absorb energy, so lead or dark metal shows up as white areas, and we saw that in the chest area. And they were consistent with the shape and location of the fragments that I recovered.
And as part of an autopsy, is a toxicology analysis done?
Yes.
And why is that done?
It's a standard protocol for us to do toxicology. It does give additional information around the what substances that person may have had in their system at the time they died.
And in this case, was there anything determined from the toxicology analysis?
Yeah, toxicology testing was negative.
Dr. Klein, do you have an opinion as to within a reasonable degree of medical certainty as to the cause of death in this case?
Yes.
And what is your opinion?
Shotgun wound of chest.
And what is the basis of your opinion?
My autopsy findings.
And do you also give an opinion as to the manner of death?
Yes.
And is that a medical finding?
Yes.
It's not a legal conclusion?
Correct.
You have an opinion as to within a reasonable degree of certainty as to the manner of death in this case?
Yes.
And what is your opinion?
Homicide.
And what is the basis of your opinion?
Both on my autopsy findings and the circumstances provided to me.
Ross.
Morning, Doctor.
Good morning.
The determination that it was a homicide is one of the roles of the autopsy report. Is that right?
Yes.
And what are the other manners available to you in your reporting?
So there are a total of 5 manners. So they include natural, accident, suicide, homicide, and undetermined.
Okay. And my understanding is homicide simply means at the hands of another.
Yes, that's correct.
Okay, due to the acts of another.
Correct.
Okay. And as Mr. Hammer was pointing out, that is not a legal conclusion by you.
Correct.
It probably is where the intersection of forensics is and medicine and the law. That's kind of where it ends at that point. Fair enough?
Yes.
Okay. So it's not a determination that a crime occurred,
Correct.
or if a crime did occur, what level or type of crime occurred.
Yes, that's also correct.
Okay. I don't have anything further.
Anything further?
No, Your Honor.
Okay, you step down.
Thank you, Your Honor.
State?
Your Honor, at this time, the state of Iowa would rest.
Ladies and gentlemen, I'm going to have you step into your chambers again. We'll take our mid-morning break. We're going to take up some issues, figure out some timeline issues as well, and then we're going to take a break, potentially. So you're free to move about. I want you to come back and at 10 to the hour, okay? Heed the admonition. Just because the state is rested does not change anything regarding the court's admonition. The case has not been submitted to you at this point, so virtually everything I've told you regarding the admonition remains.
All rise for the jury.
All right, be seated. Don't let me forget, obviously, we want to take up any motions at this time from the defense, given the state's conclusion of evidence. But before we go there, I just want to know, for the purposes of scheduling, and I guess as promised, we did have a sidebar this morning. I want to memorialize that, which I think was pretty obvious and evident based upon the court's comments afterwards, but we excused the jury at the request of counsel just to confirm that there would be some etiquette demonstrated by the media regarding the autopsy, and I just took it one step further and made clear that it was not a courtesy on their part, but an order of the court. As far as the sidebar is concerned, state concur with basically what transpired.
Yes, Your Honor.
Any further record you want to make?
No, Your Honor.
Same question to, or questions to the defense?
Same answer, Your Honor.
All right. I want to go through exhibits. We don't have to do this on the record, so reporter, you don't need to be on the record now, but don't go anywhere because I do want to make further record in a minute. If we're all on the operating from the state's point rested. We've confirmed the exhibits that have been admitted. Does the defense wish to make any argument at this time?
Yes, Your Honor, can I remain seated?
You may.
Okay, thank you. At this time, we'd like to move for a directed verdict as to count one. There is no substantial evidence that, number one, that there was premeditation on behalf of Mr. Lang, nor was there substantial evidence to establish malice aforethought given the two events that led to the shootings of Mr. Lang's gun. Because of the failure of those two primary elements of murder in the first degree, we move for directed verdict in count one. As it relates to count two, there is no substantial evidence that the firing at the Bearcat by Mr. Lang was intended to kill anyone, nor that it was targeting, given especially the status of the front of his home. It's easily simply a random shot out the hole in the front of his house. As to number three, there is no substantial evidence that Mr. Lang intended to cause a serious injury to Officer Niehaus. There's clearly evidence of an assault, but no indication that that assault was intended to cause serious injury to Mr. Niehaus. For those reasons, Your Honor, we move for directed verdict on counts 1, 2, and 3.
State?
Thank you. Your Honor, the state would resist the defendant's motion for judgment of acquittal on all three counts. Thank you.
As the parties are obviously well aware, the court, upon reviewing motions for judgment of acquittal or directed verdict, based on the sufficiency of the evidence, the court's required to review the evidence in the light most favorable to the state. The court draws all fair and reasonable inferences from the evidence, taking all of the evidence into consideration, including both direct and circumstantial evidence. The court does find a question of fact has been engendered regarding count one, and all four elements relevant to count one, to the extent that there is a question of fact that the defendant shot Sergeant James Smith. That Sergeant James Smith died as a result of being shot. As the parties are aware, with the use of a dangerous weapon, and that 12-gauge shotgun by law is a dangerous weapon, that there is presumption or that and perhaps I shouldn't say presumption, but certainly the jury can infer from the defendant's use of a dangerous weapon that there was malice aforethought, and that the jury or fact finder can infer the use by the use of a dangerous weapon, malice, premeditation, and specific intent to kill. And so, given the circumstances, the use of the weapon, the court does find that there is a question of fact regarding the defendant having acted with malice aforethought, and that the defendant acted willfully, deliberately, with premeditation, and with the specific intent to kill Sergeant Smith. And so as it relates to count one, the motion is denied. Concerning count two, the court does also find, considering the standard I set forth previously, that there is a question of fact that the defendant shot at the Bearcat, which was the armored vehicle with a number of occupants in it, primarily Chas, I forgot how to pronounce his name, I think it's Ocean, Chas Ocean, as the driver, and certainly the placement and where that initial shot was placed certainly would reflect an intent to have shot at the actual driver or operator of the Bearcat. It's a question of fact that the defendant, by using a 12-gauge shotgun with a deer slug, that he set or expected to set in motion a chain of events that would cause or result in the death of Chas Ocean or any other occupant of the Bearcat. And again, the defendant specifically intended to cause that death. And so I think a question of fact has been engendered to those 3 counts, and consequently, the court will deny the defendant's motion as it relates to count 2. Count 3 is a closer call, and I would agree with counsel to some extent, but the issue here is whether or not a question of fact has been engendered. And so, as it relates to that, I do believe, again, considering the standard I set forth above, or previously, that there was an assault upon Cody Niehaus. The defendant, certainly, a question of fact has been engendered that the defendant had the apparent ability to execute the act. And there is a totality of things that occurred throughout the course of this interaction between the defendant and Reserve Officer Niehaus, but specifically the court focusing on the choking of him, that there wasn't, that at least there's a question of fact that there was a specific intent to cause a serious injury, and that at the time Cody Niehaus was a peace officer, and at the time the defendant knew that he was a peace officer. And again, so considering all of those, I do believe that there is a question of fact for the jury as it relates to count 3, and count 3, as far as the defendant's motion is concerned, is also denied. All right, so the jury's here. At this time, it would be the defendant's opportunity to present any evidence. Does the defense intend to present any evidence at this time?
Your Honor, at this time, you can alert the court that we do not, and Mr. Lang is choosing not to testify. I think this would be a good time to make a record in that regard.
All right. So, Mr. Lang, I've had conversations with counsel throughout this, and in particular yesterday, just to confirm that we would be having discussions of this nature at some point in time throughout the trial. The decision for you to testify is obviously one that presumably you have had discussions with your attorneys about, and we are at the point then that if in fact you choose to exercise that right, you're certainly entitled to do so. And so at this stage, do you feel as though you've had sufficient discussions with your attorney regarding your decision to testify or not testify in this matter? Yes. And counsel's indicated that the decision in this particular case is such that you will not be testifying, is that correct? And do you feel comfortable in that decision at this time? Yes. Would you like any additional time to discuss that matter with your attorneys before that is a final decision? No, sir. All right. Along those lines, there will come a point in time that I will instruct the jury, and I'm sure your attorneys have already spoken to you about this as well, but nonetheless, I'm alerting you to it, that as we deal with these instructions, there will be an instruction that indicates to the jury that the defendant has opted not to testify, and they cannot draw any conclusions from that. You'll get a copy of it, and we'll talk about that in greater detail, but that's the sum and substance of it. That instruction will only be given if, in fact, you ask for it. There's 2 schools of thought as it relates to that. There's one that insists that that's something that should be given to the jury to point out that that's your right. and that the court is admonishing the jury that they cannot hold that against you because you did not testify. There's another school of thought that providing that instruction just highlights it, and highlights it unnecessarily, that you didn't testify. And so that's your decision whether I provide that instruction. And so before we make a final record on the instructions, I will inquire of you whether or not it is in fact your desire to have that instruction submitted or withheld. And I'm just giving you a heads up now to make sure that you and your attorneys discuss that, and again, similar to now, that you've had a meaningful conversation about that and you're comfortable with that decision, whichever way we go with it. If you have any questions about that, I want you to talk to your attorneys about it. Anything further from the defense regarding either one of those issues?
No, Your Honor.
Okay. Can we bring the jury in then? Tell them that we're going to recess. I'll ask the defense whether they wish to present any evidence. Check that box. Tell them we're going to recess until Monday. And then we'll just talk after that off the record informally as to how we're going to proceed. Any problem with that?
No, Your Honor. I apologize, Your Honor, I had.
Nope, I understand. I basically said that my intent would be to bring in the jury now, to advise them that, well, first of all, ask that on the record and in their presence where the defense wishes to present any evidence, and then tell them that we're going to recess until Monday.
Understood.
Okay. Let's bring him in.
All rise for the jury.
Be seated. The state's now rested. Does the defense wish to present any evidence at this time?
Your Honor, we're opting not to present any additional evidence and would rest at this time.
Okay, ladies and gentlemen, with that then we have concluded the evidentiary phase of this trial. As I've alluded to throughout, the next step will be the court providing you with the instructions, and then counsel arguing after I've read them, and I'm required by law to read them to you. Counsel and I are going to conduct some discussions regarding the instructions. We'll formalize those, we'll make copies of those and present them to you. We are going to take a recess, and it's going to be a longer recess. We're going to recess until Monday. And so you're going to be free tomorrow and for the remainder of today to allow us to work on those, to make sure that we've got those things, all our I's dotted and our T's crossed. Okay? With that, nothing's changed by way of your admonition, as the case has not been submitted to you. And so the court always has concerns, heightened concerns, when we take a break for a weekend, because that opportunity for things that might create issues and problems for all of us are just that much more prevalent over the course of a weekend. And so the court's ordering, obviously, but entrusting that you're going to heed that admonition, that you're going to stray away from whether it be the barbecue and the neighbor who's well aware of the fact that you're on this jury wants to come over, particularly after a couple of beers, and start chirping in your ear about their opinion of jury service or of this case or whatever the case may be, that you walk away. And you make it clear to them that you want no part of that and that they shouldn't be talking to you about that. Or whether you're at the dinner table and your spouse is just utterly fascinated and wants to talk about it, that you don't talk about it until the case is submitted. Your social media presence at this point in time over the course of the weekend is going to be obviously even that much more an issue, as folks are, I'm sure, becoming more and more aware of the fact that you're serving on a jury. And if you're in this community, there's only one jury trial going on, and so it won't take a lot to figure out what trial you're on, and they're going to want to be a part of it and pick your brain about it. And again, I want to make sure that you don't take any part of that. You don't do anything that would even invite it. And so all the other things I talked to you about, as far as, the research of this case, of the parties or anybody about it, the news accounts of it that might be there, whether it be current ones on TV or archived ones online, stay away from it. Okay? I will apologize up front. This is a little bit of a longer break than I would like, but it's the court's decision to take this long of a break, and so I'll take full responsibility for it. As I've alluded to always, at the conclusion of a jury trial, the court's going to have an opportunity to talk to you, and I will be happy to answer any questions that you have about the process or anything about the case in general at that time. So we'll talk in greater detail then. So heed the admonition. We'll want you back here ready to go at 9 a.m. on Monday.
All rise.
Today, state prosecutors called their final two witnesses, an Iowa DCI forensic examiner and the state medical forensic analyst, Iowa DCI ballistics forensic analyst, and the state medical examiner, who went through Sergeant Smith's injuries in very graphic detail. Dr. Dennis Klein testified that he had major injuries consistent with gunshot wounds to his upper left shoulder and the back of his leg. The state rested their case just after 10 o'clock this morning. The defense moved for the directed verdict, or yes, I can. The defense moved to take the case directly out of the jury's hands by what is known as a direct verdict or judgment of acquittal on all counts. The judge denied that. After that, the defense told the judge that Michael Lang would not be testifying and that they were not going to present additional evidence. Lang's attorney says that decision is in large part because of Judge Joel Dalrymple's decision to take self-defense pretty much off the table. Dalrymple said again today that his position has not changed. He believes law enforcement acted lawfully, therefore it is not self-defense. Dalrymple kind of really did handicap. Dalrymple really did take a machete to their knees there. Attorneys will be back in court at 1:30 to discuss jury instructions, but the jury won't be back and get the case until Monday. The judge granted the extended recess to allow the Smith family to travel to Washington, D.C. this weekend, tomorrow, for the National Peace Officers Memorial. We're probably good to go grab lunch after this. What I need to do is, Dalrymple's audio is terrible, so I want to run like that exchange, like the defense asking for the directed verdict through Otter. Just have a transcript of it, so it makes it easier for writing web stories. I mean, that's the new story today. It's if I'm honest, no one's really going to care what the medical examiner said today. Today, state prosecutors called their last two witnesses, an Iowa DCI forensics analyst and the state medical examiner who went through Sergeant Jim Smith's injuries in depth. Today, state prosecutors called their last two witnesses, an Iowa DCI forensics analyst and the state medical examiner who went through Sergeant Smith's injuries in depth. Dr. Dennis Klein testified that he had major injuries consistent with gunshot wounds to his upper left shoulder and the back of his leg. The state rested their case just after 10 o'clock. The defense moved to take the case out of the jury's hands for what's known as a directed verdict or judgment of acquittal on all counts. The judge denied that. After that, the defense told the judge that Michael Lang was not going to testify and they were not going to present any additional evidence. Lang's attorneys say that decision is because of Judge Joel Dalrymple's decision to take the self-defense argument essentially off the table. I think I'm summarizing that right when I said that they say that Dalrymple took the argument off the table.
Defense didn't have their mic on when they were talking about their motion, so we'll see how it turns out.
What's up?
The defense didn't have their mics on when they were talking about the motion. So I'll check the audio.
Yeah, because I'm definitely going to want to bite from that. That's probably going to be the defense bite I use at 6, or at 5. And I imagine, honestly, I think that'll be a defense bite, then I think I'm going to use the Dalrymple bite. Because I think we owe it to our viewers to have him explain why he took self-defense off the table. I felt so bad for the Register reporter.
Yeah, that was pretty rough.
We're live on.
Oh, on YouTube? Oh, I guess they're still taking those.
We would tell Andrew that it's over for the day in terms of streaming.
I don't know if Jeff wants the other stuff cooled or not.
It's off the record now.
He thinks it's still an open court, so he's just double checking.
Today, state prosecutors called their last 2 witnesses, an Iowa DCI forensics analyst and the state medical examiner who testified about Sergeant Jim Smith's injuries in death. Attorneys will be back in court at 1:30 this afternoon, but the jury won't be back here till Monday. The judge granted an extended recess to allow the Smith family to travel to Washington for the National Peace Officer Memorial. Show is in. Colin, good afternoon. A very busy morning here in Webster City so far. Today, the state called their final two witnesses, a forensic ballistic expert from the Iowa Division of Criminal Investigation and the state medical examiner who testified in great detail about Sergeant Smith's injuries. Dr. Dennis Klein testified that he had major injuries consistent with gunshot wounds to his upper left shoulder and the back of his leg. The state rested their case just after 10 o'clock. The defense moved to take the case out of the jury's hands in what's known as directed verdict or judgment of acquittal on all counts. The judge denied that. After that, the defense told the judge that Michael Lang was not going to testify and they were not going to present any additional evidence. Lang's attorneys say that decision is in part because of Judge Joel Dalrymple's decision to essentially take self-defense off the table. Dalrymple said again today in court that his position has not changed. He believes that law enforcement acted lawfully, therefore this is not self-defense. The attorneys will be back in court today at 1:30 to talk about jury instructions, but the jury will not be back until Monday to talk about the case and get the case and actually start deliberating on it. The judge granting an extended recess so Sergeant Smith's family can travel to Washington, D.C. for the National Police Officers Memorial. In Webster City, Daniel Perot, News 7, KWWL. Cool.